out of the discourse, but the president gave a further assurance that not only is Akonta Mining not engaged in illegal mining activity in any forest reserve, as he spoke yesterday.
MPP Ashanti Regional Chairman, popularly known as Chairman Wontumi, in fresh trouble. Yes, news trooping in is indicating that Wontumi has been sentenced to 20 years in prison. Yes, we all know that illegal mining, which is galamsey, has been destroying our water bodies, destroying our lands, causing so many deaths and all that. And Wontumi has been doing back and forth in court in previous years. Yes, so right now the court has come to a conclusion that Wontumi has to serve 20 years in prison. So this is what City FM posted. MPP Ashanti Regional Chairman Bernard Enchibusiako, Chairman Wontumi and Akonta Mining found guilty and convicted for offences of assigning mining licenses without ministerial approval and purposefully facilitating unlawful mining. Yes, so Wontumi has been jailed because of his participation or his company's participation in illegal mining in the Western region. I think Samrabo, yes, in the Western region. So Pauls also posted that Chairman Wontumi jailed for 20 years after conviction on 6 mining charges. The Accra High Court has sentenced Bernard Enchibusiako, popularly known as Chairman Wontumi, to 20 years imprisonment after finding him guilty of offences linked to illegal mining on the Samraboy concession in the Western region. Chairman Wontumi was sentenced to 20 years imprisonment after being convicted on 6 illegal mining-related charges. The court also fined him 10,000 penalty units with a 3-year default prison term to run concurrently. Akonta Mining Company Limited was fined after the court considered mitigation circumstances. So the judge's name, yes, Justice Audrey, forgive me, Kosivite, presiding over the criminal division of the High Court, delivered the judgment on Monday, July 20th, bringing to a close one of Ghana's most high-profile prosecutions involving illegal mining, popularly known as galamsey. So, you see, there have been reports that many high-profile people in the country are involved in this illegal mining, but there hasn't been any proof or enough evidence proving that any high-profile person is involved. So Chairman Wontumi has been one of the people who has been often linked to this practice. So he's one of the people who has been going to court most of the time because of his involvement in this illegal mining. In addition to the custodial sentence, the court imposed a fine of 10,000 penalty units on the Ashanti Regional Chairman of the opposition New Patriotic Party. Should he fail to pay the fine, he will serve an additional 3-year prison term, although the court ordered that the custodial sentence and the default term ran concurrently. The court convicted Mr. Enchibusiako on all 6 charges, including assigning mineral rights without the required ministerial approval and intentionally facilitating an unlicensed mining operation. So one of the charges is he assigned mineral rights without the required ministerial approval. So he went ahead without gaining the required approval that he should get before he can enter into this business. Contrary to the Minerals and Mining Act 2006, Act 703 as amended. Under the law, the offence attracts a custodial sentence ranging from 15 to 25 years. So the minimum is 15 years and the maximum is 25 years for the offence. But the court gave him the 20 years charge. The High Court also sanctioned Akonta Mining Company Limited, the company linked to Mr. Enchibusiako, but stopped short of imposing a custodial sentence. Instead, the company was fined after the court took mitigation factors into account, meaning it avoided the prison sentence handed to its controlling director. Court reject plea. So his lawyer pleaded for a reduced sentence. So instead of the 20 years sentence, his lawyer wanted to give him 15 years rather, which is the minimum, because this was the reason. He urged that his client had cooperated with investigators throughout the trial, appeared before the court whenever required, expressed remorse, and had no previous criminal convictions. The defense also cited Mr. Enchibusiako's contribution to his community and his responsibilities as a family man. So his lawyer pleaded that they should reduce his sentence, and the reason being that Wontumi was helped with investigations. He always appeared in court whenever he was needed, and his contribution to the community, and also he's a family man, and he has no prior criminal. He hasn't been charged of any criminal offenses before. So these are the reasons that his lawyer gave so that they could reduce his sentence. But the judge still imposed the 20-year custodial sentence after considering submissions from both the prosecution and the defense. The case centered on allegations that Wontumi, together with Akonta Mining and an associate, allowed mining activities to be carried out on the company's concession at Samraboy without the approval required under Ghana's mining laws. So he was charged because he allowed someone else, he allowed an associate, he allowed mining activities to be carried on the company's concession without gaining the required approval first. So he should have allowed required approval to come before he can allow such act to be done. But he went ahead and gave the approval without getting the required approval he needed under the law. Throughout the trial, the MPP regional chairman pleaded not guilty and mounted several legal challenges, including attempt to hold proceedings and a late application seeking constitutional interpretations of provisions of the Minerals and Mining Act. The applications did not prevent the High Court from delivering its judgment. The prosecution has attracted widespread public attention because of Wontumi's political profile and has featured prominently in the national debate over the enforcement of laws against illegal mining and the prosecution of politically exposed persons. So this case has gained much attention because most Ghanaians are of the assertion that because Wontumi is a political figure in the country, he will not be jailed. It's like I don't know how to put it. It's like the law is, should I say, the law is protecting him, or high-profile people are behind him, so he can't be jailed. So this case is of much interest to the Ghanaian people. So most people are happy because finally we have gotten someone that has been jailed because of illegal mining. And we all know there are so many people who are involved in this practice that has to be to give accountability, like how Wontumi has been charged and given accountability. There are so many people who has to also give accountability for their actions, and I know one by one we will get them one by one. Yes, so this is what Paul's News posted on their site. This is what they posted, and they've given us the reasons Wontumi has been charged and all that. So this is what his lawyer had to say about this particular issue.
Indeed, I must say that
Is that the outcome of?
the outcome of the trial.
Okay.
having culminated into a conviction and sentencing. Because under normal circumstances, one would have thought that at least once a person is charged with assignment of mineral rights without authorization, it was right that the Lands Act clearly defines what assignment is. And assignment is by way of a written instrument. And if there was none throughout the trial, and that a person could be convicted and sentenced on same, then it's really a worrying trend. And what can we do except to consult our clients and fashion out the way forward, and it will certainly come out.
But the charges were brought under the Mining Act, right?
Yes, certainly it was brought under the Mining Act. But the Mining Act doesn't talk of assignment. It talks in terms of assignment. The specific legislation that regulates the conduct of land transactions is the Lands Act of 2020. Yes, Act 1036. It regulates the conduct of land transactions. So if you want to really understand what assignment means as far as land transactions are concerned, then you have to go to the Lands Act. And clearly the Lands Act talks of assignment to be a written instrument, but we did not see it. And said clearly, once he has been convicted on assignment without mineral right authorization, it's clearly mind-boggling, and I am not comfortable with the setting.
So are you happy with the judgment that the judge gave to Wontumi, or you feel they should have reduced the sentence, or you feel the 20 years and the fine given are just the perfect punishment to serve as a caution and a warning to others? We all know there are so many people involved in this act, and if this is what is going to help in protecting our lands, protecting our water bodies, protecting our trees, then I feel this is the best way to go. Let me know your comments in the comment section. What do you think about this?